Hello and welcome to the Scum and Villainy Report. Today we're going to be looking at the Supreme Court of New York as it looks at Letitia James, the Attorney General, and her case against Donald Trump. Let's roll the tape.
It's really critically important that everyone understand, as was mentioned by Mr. Verhara, that filing a lawsuit, simply opening up an investigation, can ruin lives. And so with respect to Donald Trump, we need to follow his money. We need to find out where he's laundered money. We need to find out whether or not he's engaged in conspiracy and whether or not he's colluded not only with Putin, but also with China as well.
But wait, there's more.
What would you say to people who say, oh, I'm not going to bother to register to vote because my voice doesn't make a difference, or I'm just one person?
I say one name, Donald Trump. That should motivate you. Get off your ass and vote.
Will you sue him for us?
Oh, we're going to definitely sue him. We're going to be a real pain in the ass. He's going to know my name personally.
I love it. He probably does already.
As you can see, James campaigned heavily on holding Trump accountable, which immediately raises eyebrows about the intent behind this investigation. Are we witnessing a legitimate pursuit of justice? Or is this a case of weaponizing the legal system for political gain? It's clear the justices will want answers to this very question. And with that, let's jump right in. We're about to see the New York Attorney General's office in front of the Supreme Court of New York.
May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly violated...
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
Oh, several responses.
And I want to add to his question, and little to no impact on the public market.
All right, so what we're seeing here is pretty remarkable. New York Attorney General Letitia James' office is being grilled by the Supreme Court of New York for her decision to go after former President Trump. Now, while legal battles between political figures are nothing new, what makes this case stand out is that the laws James is using have never been applied in this way before. The court seems to be really honing in on this and wanting to know the why behind the decision.
Well, maybe I'll take that first, Your Honor, and work backwards. There was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here, but it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
But also the financial statements were coming in each year, and they were important, critical to the loans each year because Deutsche Bank was reassessing the risk every single year, and it was using...
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
You can really feel the tension in the room here. The court is not letting her off easy. They're asking her to justify why she's pursuing Trump with laws that, frankly, have never been used in this way. And this is important. The foundation of our legal system relies on consistency and precedent. Two things that are being challenged right now. What we're seeing might set a new precedent, but it's important to ask if that's a road we really want to go down. Remember, justice should be blind, not selective. If certain laws are only pulled out for specific people, that raises questions about fairness. Is this about Trump, or could this become a broader tool against any political figure down the line?
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But
And-
it wasn't wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing?
You're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money, and that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
James's office is in a tough spot here. The court's probing seems aimed at whether her office is stretching legal boundaries to target a political figure. What we're really seeing is a deeper concern. Should laws be used in ways they weren't originally intended? This line of questioning is making it clear that the court is asking, are you setting a dangerous precedent here? And this is where it gets even more interesting. The Supreme Court is diving into the legal justification for these charges. They're saying, look, we've never seen the law applied in this manner, so why now? It raises the question of whether this is a case of interpreting the law creatively or of weaponizing it in ways that are outside its original scope. For many, this case isn't just about Trump. It's about how far political figures can go when they hold legal power. If James is willing to break new ground with these laws, it could pave the way for future cases where legal actions become political weapons. And you can see why the court is concerned about that.
Example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes,
It didn't affect the public, at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do? And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, that where people don't claim harm. So what is the limiting principle?
I notice you say the ordinary standard on page 55 of your brief. You say these deceptive strategies had a capacity, a tendency to deceive, because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings, and you cite to General Electric. Mm-hmm. Isn't the test here whether they were likely to mislead Deutsche Bank or Ladder Capital or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and entities in business.
The justice's tone is telling. They seem frustrated, not just with the answers they're getting, but with the broader implications of this case.
I have a question that's
And I'll
similar
give
to
you
Judge
time for a
Rosado's,
second.
actually, which is the immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Now, James's office will argue that she's doing her job, pursuing justice wherever it leads. But in cases like these, the line between justice and political warfare can get pretty blurry. This case is testing the limits of that line. So what do we take away from this? On the surface, it's a legal battle over fraud allegations. But when you dig deeper, it's about precedent, the use of power, and how far the law can or should go when the target is a political figure. If James succeeds, this might open the door for more aggressive legal actions in the future. If she doesn't, well, it could mean the courts are drawing a line in the sand, protecting not just Trump, but any future political figure from similar legal tactics. So now it's time to let me know what you think. Do you believe in the integrity of our legal system? Do you think it's being manipulated for political purposes? No matter which side of the political spectrum you fall on, this case raises serious questions about fairness, power, and the future of legal precedent in the United States. Comment down below and let me know your thoughts. See you next time.